2026 isn't just another year for Britain, it's the year the rulebook changes. From your job to your rent, from the adverts you see to the food you buy, almost every corner of daily life will feel the impact of new UK laws reshaping fairness, safety, and accountability. These reforms aren't small tweaks. They redefine what it means to work, live, and spend in modern Britain. Whether you're an employee, a tenant, a business owner, or a commuter, the choices made today will rewrite your tomorrow. Here are 10 things every Brit should know before the new laws arrive. Number 1. Major employment rights reforms. From April 2026, the UK is expected to introduce one of the most wide-ranging changes in employment law in more than a decade. The proposed Employment Rights Bill expands protection for workers from the very first day of their job. Under the new framework, employees will gain day one rights against unfair dismissal, flexible working requests, and parental leave eligibility. This move aims to strengthen workplace security, especially for younger employees and those in temporary or part-time positions. The government's consultation suggests these reforms will cover millions across retail, hospitality, and logistics sectors that have long relied on zero-hour or casual contracts. Another key element involves tightening rules on employment tribunals and compensation timelines. Workers will be able to bring forward complaints more quickly, while employers will face stricter requirements for record keeping, pay transparency, and grievance response deadlines. These reforms come amid growing awareness of wage disparity and post-pandemic workplace imbalance. The Labour government's stated ambition is to create a fair work economy, ensuring consistent rights regardless of job type or contract status. Businesses may need to revise HR policies, onboarding documentation, and dismissal procedures to comply before the 2026 deadline. For employees, this shift could mean greater job stability, improved work-life balance, and a more open route for reporting harassment or unsafe working conditions. For employers, the emphasis now falls on accountability and communication. Legal experts warn that failing to adapt could lead to penalties or reputational damage. The Advisory, Conciliation and Arbitration Service, ACAS, is preparing updated guidance to help both sides understand the transition. Whether one works in a small cafe or a multinational firm, this reform is set to redefine how fairness, flexibility, and worker dignity operate across Britain's evolving labour landscape, signalling a powerful start to the 2026 legal transformation. Number 2. Fire and rehire. Restrictions and employer duties. By 2026, the UK will formally enforce new restrictions on fire and rehire tactics, a controversial method some employers have used to dismiss staff and immediately re-employ them under less favourable terms. The new law requires companies to engage in transparent consultation processes before any contractual change. Employers will need to provide written evidence proving that cost-cutting or restructuring is the last resort, not the first. This shift reflects growing political and public pressure to end exploitative practices that erode job security and undermine employee morale across key sectors like transport, retail, and manufacturing. Under the updated Statutory Code of Practice, any organisation failing to follow fair negotiation standards could face significant financial penalties, with employment tribunals empowered to uplift compensation awards by up to 25%. The law also introduces mandatory notice periods and documentation requirements to ensure every worker fully understands proposed contract alterations. Trade unions and labour lawyers have welcomed these changes as a major step toward restoring workplace balance. The government expects the policy to encourage honest dialogue between management and employees, avoiding the abrupt and distressing terminations seen in past high-profile cases. For workers, the reform represents more than procedural fairness. It strengthens the psychological contract between employer and employee. Businesses will have to justify any dismissal decision through a formal evidence trail backed by clear financial reasoning. This move should reduce industrial unrest and help stabilise the post-pandemic labour market. HR departments are now being advised to invest in mediation training and compliance audits before the law takes effect. By shifting focus from confrontation to cooperation, the 2026 Fire and Rehire framework aims to rebuild workplace trust and establish long-term employment relationships grounded in transparency, respect, and lawful negotiation. Number 3. Advertising restrictions on less healthy foods. Starting January 2026, the UK will roll out a landmark policy targeting junk food marketing in an effort to reduce rising obesity rates and long-term public health costs. The new legislation bans high-fat, salt, and sugar food advertisements on television and online before 9 p.m. Companies promoting snacks, sugary drinks, or processed meals will face strict limits on digital ads directed at children. This change, first delayed from 2025, forms part of the government's broader Healthy Britain 2030 strategy, which aims to reshape eating habits and reduce preventable diseases. Analysts estimate that the move could cut children's annual calorie intake by thousands and push major brands to reformulate their recipes. For food producers and advertisers, the impact will be immediate and significant. Media agencies will need to review every campaign to ensure compliance with the new Ofcom and ASA regulations. Retailers will be urged to feature healthier items more prominently both in-store and online. Brands, such as supermarkets and fast food chains, are already shifting marketing budgets toward lower calorie or plant-based products to stay visible within the new framework. Those ignoring the rules risk fines and public naming, as enforcement powers expand through the Department of Health and the Competition and Markets Authority. The law is also expected to reshape consumer culture. Families will see fewer high-sugar product promotions during family television hours and on social platforms like YouTube Kids. Campaigners view this as a cultural turning point toward responsible advertising, while critics worry about revenue loss for broadcasters. Economists, however, predict long-term gains in workforce productivity and healthcare savings. For households across Britain, the 2026 restrictions are not just about fewer adverts. They symbolise a national shift toward accountability in how food, health, and marketing intersect in everyday life. Number 4. Consumer credit and buy now, pay later protections. By mid-2026, new consumer credit regulations will bring stronger safeguards for shoppers using buy now, pay later (BNPL) services. The Financial Conduct Authority (FCA) will begin full supervision of these products, ensuring lenders must perform affordability checks, issue clear contracts, and provide customers with transparent repayment schedules. This change comes after a sharp rise in household debt linked to unregulated BNPL schemes offered by major fintech firms. Under the 2026 framework, all providers will be required to hold credit licenses and face penalties for misleading marketing or failing to treat borrowers fairly. The reforms seek to protect younger consumers who rely on short-term installments for fashion, tech, and groceries. Retailers partnering with BNPL platforms will also face new disclosure duties, making sure customers understand interest costs, late fee risks, and credit score implications. Every advertisement and checkout page must display plain language terms vetted by regulators. The Treasury expects these changes to increase financial literacy while preventing aggressive lending. The reforms will apply equally to online and physical stores, tightening a loophole that previously allowed unregulated deferred payment schemes to flourish. For financial institutions, 2026 will mark a transition toward responsible lending standards designed for the digital era. For consumers, this shift brings a safer, more predictable credit experience. Missed payments will trigger early warning alerts instead of immediate penalties, and customers will gain access to independent dispute resolution services through the Financial Ombudsman. Data sharing between credit bureaus will also improve, reducing the risk of hidden debt accumulation. Economists predict the reforms could stabilise personal finance behaviour across the UK, encouraging budgeting discipline while preserving flexibility for responsible borrowing. As the FCA rolls out the new code, the 2026 Consumer Credit Overhaul signals a clear message. Convenience must never outweigh financial protection in Britain's modern digital marketplace. Number 5. Immigration and settlement rules. In 2026, the UK will enforce significant updates to its immigration and settlement framework, reshaping how skilled workers, students, and family members enter and remain in the country. The most notable shift involves a rise in the minimum salary threshold for skilled worker visas, moving closer to the national median wage to prioritise high-value roles. This change aligns with the government's goal of reducing net migration while strengthening domestic job opportunities. Additionally, employers sponsoring foreign staff will face stricter compliance audits, requiring evidence that no suitable UK-based applicant was overlooked before hiring from abroad. These new measures aim to balance economic growth with labour market fairness. The settlement pathway will also evolve. Permanent residency or indefinite leave to remain (ILR) will require longer qualifying periods and stricter English language and integration standards. The government plans to introduce an updated civic life test, focusing on British law, values, and social contribution. Family visa applicants may see adjustments in financial requirements and faster digital processing under the Home Office's modernised immigration system. For international students, post-study work opportunities will remain available, but subject to tighter conditions ensuring genuine skills, transfer and employer sponsorship integrity. For migrants already in the UK, the reforms are designed to create transparency and accountability across every visa category. The digitalisation of immigration records through the e-visa platform will replace physical residence permits entirely, simplifying travel and verification. Border agencies and employers will gain real-time access to status checks, reducing document fraud and delays. Critics argue the higher salary thresholds could limit access for essential sectors like care and hospitality, while supporters see it as a long overdue step towards sustainable migration. As Britain adjusts to post-Brexit realities, the 2026 immigration laws signal a decisive shift towards security, digital efficiency, and skill-based residency. Number 6. Self-driving and autonomous vehicles framework. By late 2026, the UK will implement a groundbreaking legal framework for autonomous vehicles, transforming how transport safety, insurance, and accountability are defined. Following years of trials under the Centre for Connected and Autonomous Vehicles, the new law will officially recognise self-driving systems as authorised autonomous features. Once a vehicle is operating in self-drive mode, the driver will no longer be legally responsible for navigation or collisions. Liability will shift to the manufacturer or software provider. This landmark step positions the UK as one of the first European nations to adopt full legal status for automated vehicles, aiming to attract global investment and accelerate transport innovation. The framework introduces strict safety certification and data recording rules, requiring every self-driving vehicle to log sensor and AI decision data to support post-incident investigations. The Department for Transport will also establish a new automated vehicle regulator to monitor compliance and coordinate recalls. Insurers will be mandated to provide coverage that recognises shared responsibility between the human user and the system developer. Public roads across London, Oxford, and Manchester are already being prepared for expanded pilot routes. The 2026 regulations will further integrate 5G-based communication systems, enabling real-time updates and cooperative traffic management between autonomous fleets. For everyday drivers, the law promises a future of greater convenience and reduced accidents, though not without challenges. Safety advocates emphasize the need for rigorous testing, cybersecurity standards, and driver re-engagement protocols in case of emergencies. Car manufacturers must meet transparent performance benchmarks before public release, while local councils will adapt infrastructure to accommodate advanced navigation. Analysts predict that by 2030, self-driving logistics vehicles could save billions in fuel and efficiency costs. The 2026 Autonomous Vehicle Act represents a decisive leap toward intelligent mobility, merging technology, regulation, and human safety into one forward-looking transport vision. Number 7. Data protection and automated decision-making changes. The UK's Data Protection and Digital Information Bill, expected to take full effect in 2026, will modernise how organisations handle personal information and automated systems. These reforms aim to simplify compliance for businesses while preserving individual privacy rights under the UK GDPR. One of the most significant updates concerns automated decision-making, where algorithms determine outcomes such as job applications, loan approvals, or online recommendations. Under the new law, citizens will gain stronger rights to request human review of algorithmic decisions and receive clear explanations about how their data influenced a result. This marks a vital balance between digital efficiency and ethical transparency in a rapidly AI-driven economy. Businesses collecting consumer data must now demonstrate explicit consent mechanisms and maintain simplified privacy notices that users can actually understand. The Information Commissioner's Office, ICO, will gain expanded powers to audit compliance and issue larger fines for unlawful profiling or hidden data processing. Tech companies relying on large-scale data analytics will need to assess the fairness and bias of their algorithms through documented risk assessments. Meanwhile, cross-border data transfers will continue under the UK's Data Adequacy Framework, ensuring that information shared with allied nations meets minimum security standards. These steps align with Britain's ambition to build a world-leading yet flexible digital economy. For citizens, the 2026 update means more control and clarity. Users will be able to manage cookie preferences, data access, and AI interactions through unified dashboards offered by online platforms. Employers, financial institutions, and retailers will need to reconfigure internal policies to ensure human oversight in automated processes. Experts believe these reforms could enhance public trust and encourage responsible AI adoption across healthcare, finance, and education sectors. By redefining privacy as empowerment, the 2026 data law signals a new era of accountability in Britain's digital transformation. Number 8. Product regulation and metrology reforms. In 2026, the UK will move forward with sweeping product safety and metrology reforms, reshaping how goods are certified, labelled, and sold across domestic and international markets. The new rules, led by the Department for Business and Trade, will replace certain EU-derived standards with a modernised UK product conformity system. The long-delayed switch from CE marking to the UKCA, UK Conformity Assessed, label will become fully mandatory for most industries, marking the final stage of post-Brexit regulatory independence. This shift ensures that all goods, from electronics to building materials, meet updated national safety and environmental benchmarks before reaching consumers. Manufacturers and importers will be required to maintain digital compliance documentation accessible through scannable QR codes, allowing regulators and buyers to verify authenticity instantly. The Office for Product Safety and Standards, OPSS, will expand enforcement powers, targeting counterfeit, unsafe, or inaccurately labelled goods in both physical and online marketplaces. Meanwhile, metrology reforms will introduce updated measurement standards reflecting modern technologies such as smart sensors and automated weighing systems. This update aims to improve consumer confidence and industrial precision across retail, energy, and logistics sectors. Businesses that fail to transition by the 2026 deadline risk losing market access or facing financial penalties for non-compliance. For British consumers, the result will be safer, more transparent products backed by traceable data and quality control. The reforms will also support small businesses by simplifying conformity procedures and reducing unnecessary paperwork through a single digital registration system. Exporters will benefit from new mutual recognition agreements with key trading partners, including Australia, Japan, and Canada, easing border checks for compliant goods. Industry experts view these changes as a long-term investment in reliability and global competitiveness. The 2026 product and metrology reforms will ultimately redefine trust, precision, and accountability in every product sold within the United Kingdom. Number 9. Rental and tenancy law reforms. The year 2026 will bring some of the most anticipated changes to rental and housing law in decades, following the full rollout of the Renters' Reform Bill. The centrepiece of this law is the abolition of Section 21 no-fault evictions, meaning landlords will no longer be able to remove tenants without providing a valid reason. Instead, every tenancy in England will convert into a single system of periodic tenancies, giving renters stronger stability and flexibility to leave with proper notice. The reforms seek to create a fairer balance between landlord rights and tenant security, while reducing homelessness and exploitation in the private rental sector. The law will also modernise how rent increases and disputes are handled through improved mediation services and digital tracking of tenancy agreements. For landlords, the 2026 framework introduces new property standards and registration duties under a national landlord database. Every rented home must meet updated safety, energy efficiency, and habitability requirements verified by local councils. Landlords seeking possession for legitimate reasons, such as selling the property or moving in a family member, will need to follow clearly defined legal procedures. The government's aim is to remove rogue operators while preserving stability for responsible property owners. These rules coincide with the Housing Ombudsman's expanded powers to handle complaints quickly and ensure enforcement consistency across England. For tenants, the impact will be immediate and tangible. The right to challenge excessive rent increases, improved protection against harassment, and guaranteed repair obligations are now legally reinforced. Housing charities predict these changes will empower millions of renters who have long faced insecurity. At the same time, letting agents and landlords must adapt to greater transparency and accountability across all transactions. The 2026 tenancy reforms mark a decisive cultural shift, positioning housing not as a privilege, but as a regulated, fair, and sustainable right within modern Britain. Number 10. 0 hours, social care, and flexible work reforms. By 2026, the UK will enforce a major overhaul in worker rights for 0 hours and social care employees, aiming to close long-standing gaps in job security and fair pay. The new rules will give anyone working variable hours the right to a predictable work schedule after 12 weeks of continuous service. Employers will be required to provide written terms outlining minimum weekly hours and advance notice for shift cancellations. This reform responds to years of criticism about precarious contracts that left workers without guaranteed income or stability. The government's stated objective is to ensure every worker, regardless of role, has access to consistent conditions that support both financial security and family life. The social care sector, one of Britain's largest employers, will receive special attention. New national standards will introduce minimum pay guarantees, mandatory training pathways, and enhanced whistleblower protection. Care workers, who have often faced irregular hours and burnout, will finally be recognised under a unified code defining fair workloads and benefits. Local councils will gain additional funding to enforce compliance and raise service quality. Meanwhile, gig economy and platform workers will see updated definitions of employment status, ensuring eligibility for holiday pay, sick leave, and pension contributions. This marks a significant evolution in the UK's commitment to ethical labour practices in a post-pandemic world. For employers, the shift requires operational change, particularly in scheduling systems, payroll software, and contractual structures. Non-compliance could attract penalties from the Employment Agency Standards Inspectorate. For workers, the reform represents dignity and balance, a chance to plan lives beyond uncertain shifts and last-minute cancellations. Economists expect reduced staff, turnover and higher productivity across key industries. The 2026 Flexible Work and Zero Hours reform is therefore more than legal housekeeping. It is a statement of national values, declaring that fairness, respect, and reliability belong at the core of Britain's future workforce. As 2026 approaches, the UK stands on the edge of one of the most transformative legal shifts in decades. From stronger worker protections and transparent tenancy rights to tougher digital privacy rules and safer consumer standards, every reform carries a message that fairness, accountability, and innovation must guide Britain's future. These laws are not abstract policies. They will shape the pay you receive, the contract you sign, the products you trust, and even the technology that drives beside you on the road. Understanding them today means staying prepared, informed, and empowered when they take effect. For citizens, this is the time to review contracts, update compliance practices, and rethink everyday choices. For businesses, it's an opportunity to rebuild trust and credibility in a fast-changing world. The 2026 legal landscape will reward those who adapt early and stay ahead of the curve. If you found this breakdown useful, hit the like button, share it with your friends, and subscribe for more clear, factual insights on how new UK laws will affect your work, money, and daily life. And in the comments, tell us, which of these 2026 changes do you think will impact you the most?